Hi guys, I hope you're doing great. My name is Mutiaba Conrad, a lawyer by profession and also a private law tutor. And today basically we're going to be looking at the doctrine or the maxim known as non est factum. But please, before we start on our class, do not forget to subscribe, like and share. Just go down on the subscription button and you click on it so that you'll be able to get notifications whenever any video is released. Then for those that would also require to have private law tutorial sessions, please do not hesitate to contact us. Down in the description box, you'll be able to find our contacts. So let's start right away with the doctrine of non est factum. In this class, we are basically going to be defining the maxim of non est factum, but also secondly, we'll be looking at those legal requirements that govern this doctrine. For the doctrine to be applicable, there are certain legal maxims and there are certain requirements that must be in place. And then lastly, we'll also be within our discussion looking at the legal regime governing the maxim of non est factum. We'll be looking at case law and also looking at the act governing the same. So let's start right away with the definition of non est factum. Basically, the maxim non est factum simply means that this is not my deed. So the common scenario here that arises is a party who is before court. Maybe there is a document that was signed and such a person is saying that this document was entered maybe as a result of mistake or misrepresentation, or maybe that they did not know the nature or the contents of the document. And as such a party relying on the maxim would be trying to challenge the authenticity or the contents of such a contract. So that is the common scenario within which the maxim of non est factum applies. So basically, the party would be saying that the contents of this document and the document itself is not my own. And that's why we're saying that non est factum means that this is not my deed. Now, it's important, however, to highlight from the very beginning that this maxim is really governed by certain restrictions. Okay, so there are certain parameters within which you must fall. And we are going to be examining those parameters a little bit more in detail. The first parameter is that where a party signing is subject to some weakness, for example, blindness, senility, or even illiteracy. So the party who is relying on the doctrine of non est factum must be one who is either illiterate, they didn't understand the contents, maybe the document was in English or in German or in Chinese, whereas actually such a party does not understand what the contents of the document are about. But it could also be that the person is of old age or they were blind, they did not understand, they were not in a proper mental state. Then definitely the doctrine of non est factum would at that material time come into play. But also at this juncture, I invite you to look at the authority, a very interesting case of Opia Moses versus Klukia, Lumango, Roslin, and others. It's a High Court civil suit, number 22 of 2013, judgment of Justice Stephen Mubiro. And he puts up a very interesting holding where Justice Stephen Mubiro held that a person who doesn't know English but claims to understand the contents of a document is not protected by the Illiterates Protection Act. So basically, that was the holding in the case. It's also very important to note at this juncture that you can also look at the Illiterates Protection Act, Cap 78. It's the law that governs basically the signing of agreements or contracts between or with persons who do not understand English or any foreign language. So that is the legal framework. And of interest to you is Section 2 and Section 3 of that act. We'll be examining them a little bit more in detail, but I wanted to bring in that authority at this juncture so that you're able to appreciate the principle a little bit more. Let's now proceed to look at the second restriction or the second requirement to the application of the doctrine, which is that the document was misrepresented. So it must be that the other party must have represented that the document is something different than that was signed. Okay, so the aspect of misrepresentation must also somehow come in, that the other party who is entering a contract with someone of unsound mind, or someone who is senile, or someone who is of old age, or someone who is not educated must have known that the contents of the document are otherwise, and they attempted to represent them otherwise. I encourage you to look at the locus classicus. It's a Supreme Court decision, a very interesting case of Kasala Growers Cooperative Society versus Kakoza and another. It's a Supreme Court Civil Appeal number 19 of 2010. This decision is very authoritative on entering contracts with uneducated persons. And basically, I'll just briefly take you through two interesting holdings. The first one being court holding that Section 3 of the Illiterates Protection Act, Cap 78, enjoins any person who writes a document for or at the request or on behalf of an illiterate person to write in the jurat of the said document his or her full details. So that's really very, very important. And also of interest was the second holding in that case, which is that a person who writes a document with an educated a person writing a document with another party who is not educated must explain properly the contents of that document to the other party and also ensure that such a party has understood those contents for which this other party is attempting to contract them on. Very interesting holding there. Also, I encourage you to go online and look at the case of Chimboa versus Casitro. It is civil suit number 197 of 2009. It's judgment of Justice Yasin Nyanze. Please, you go and examine it. It also puts up a very interesting discussion on the maxim of non est factum and also entering contracts with illiterate persons under the Act. So very interesting. You should ensure that you look at it. Secondly, thirdly, the last requirement on which the doctrine of non est factum operates is that the party that signed it must have tried to authenticate the genuinity or how genuine the document is, and by themselves they were also not negligent. So this is really very important. One, they must have done everything to ensure that they try and find how genuine the document they are entering in is. And also secondly, they must not have been negligent in their course of action or during the negotiation. And the reason why this is really important is because the maxim on which contract law really applies, which is that the court has no duty to enter or to interfere with the freedom, the doctrine of freedom of contract, that parties who really enter contract have that freedom to contract on the terms that they see fit, and that it's not the duty of court to come in and interrupt adult citizens of this world who attempt to enter contract. This is where this requirement is best. So even the party who really is attempting to rely on this doctrine must have done everything within their means to ensure that the one, they are not negligent, but also secondly, that they authenticated the document. This is really, really very, very important, as court will not attempt to help a person who sleeps on their rights or really who does not take the necessary due diligence that is expected of any sane human being. Authority for that position, I encourage you to go and look at the case of Sanders versus Anglican Building Society. It's a case of 1971 SC, page 1004. And the brief facts of this case were that an elderly lady who was actually a widow decided to transfer her property to her nephew. The document was drawn by a gentleman called Lee, a dishonest friend of the nephew, which he conveyed onto himself. So he drew a document and conveyed this property onto himself. Now, the widow pleaded non est factum, that this was not her deed and that she actually didn't understand or intend the contents of the document to be as so. And of course, at first she succeeded, but on appeal to the House of Lords, the House of Lords held that there was insufficient difference between the documents she signed and had intended to sign, and that both gave her rights in the property to another party, and that she had not done enough to check its nature, and as such the plea of non est factum was disregarded by court. So I think you see how courts in certain instances will really be harsh on a person who is intending to rely on the doctrine of non est factum. But also, before we conclude today's class, I encourage you to look at a very interesting case of Justice Stephen Mubiru, one of the best judges in Uganda, and the cases Opia Moses versus Klukia Lumago Roslin and others. It's a High Court civil suit number 22 of 2013. And in this case, Justice Stephen Mubiru puts up a very interesting holding where he says, of course, the holding should be in context of the facts of the case, where Justice Stephen Mubiru held that a person who doesn't know English but claims to understand the contents of a document is not protected by the Illiterates Protection Act. So that's really very, very important. You always have to show that the person actually did not understand the contents of the document, or maybe they were illiterate, they didn't understand the language, or maybe they were senile, or they're of old age, or they are blind, and they did not understand or appreciate the contents of the document. So, ladies and gentlemen, that was all in today's class on the doctrine of Non Est Factum. And once again, I encourage you to subscribe, like, and share my channel. And also those students interested in private law classes, you can always engage us and we can reach out to you to give you that extra help. That extra polish as a student is really, really very, very important. See you next time, and thank you very much. May the God bless you. Bye-bye.